Hello, and welcome to today's training on the EU Victims Directive and Undocumented Victims of Crime. My name is Alina Smith, and I'm an advocacy officer for an organization called PICUM. PICUM is the Platform for International Cooperation on Undocumented Migrants. We're a network of NGOs from 31 countries, 156 organizations in total, working to ensure social justice and human rights for undocumented migrants. So the starting point for our discussion today about the EU Victims Directive is Article 1. As you know from your earlier training on this directive, the purpose of the Victims Directive, as set out in Article 1, is to ensure that victims of crime receive appropriate information, support, and protection, and are able to participate in criminal proceedings. Now, that article ends with the following sentence: "The rights set out in this directive shall apply to all victims in a non-discriminatory manner, including with respect to resident status." Now, the clear upshot of Article 1 is that it was the intention of EU legislators that all victims of crime should fully benefit from all the provisions of the directive, and that resident status would pose no barrier to the enjoyment of rights by any victim of crime. And this is consistent with Recital 10. Under Recital 10, member states should take the necessary measures to ensure that the rights set out in this directive are not made conditional on the victim's resident status. Now, what we can understand from the inclusion of this language explicitly in the Victims Directive is an acknowledgement that resident status, in fact, can create obstacles to victims enjoying their full rights. And so I wanted to, at this point, take a step back and consider the ways in which resident status can affect a person's risk of becoming a victim of crime, and also affect a person, in the absence of the rights of this directive being in force, that person's ability to access justice, support, and protection. So we understand from experiences on the ground and from the evidence that we do have that people without secure resident status do, in fact, face a disproportionate risk of victimization of all types. And why is this? This is because authorities tend to prioritize the enforcement of immigration rules ahead of undocumented victims' rights. And so when they're confronted with a situation, an incident, where the people involved, there may be a question about the migration status of the people involved, they will put on their hat of migration enforcement officers or authorities and deprioritize the way they would normally confront a situation in terms of addressing the needs of the victim. As a consequence, perpetrators are in a position to exploit this fact to manipulate, trap, and control victims. And so what we see is that perpetrators are well aware of the fact that they are in a situation where their victims can be abused without consequences. And so what this sets up is a cycle of repeat victimization. So what are the types of crimes that are committed against people with precarious status? Now, we hear much about the exposure that some migrants may face to forms of violence, including human trafficking, in the course of their journey to Europe. And there are specific EU frameworks addressing, in particular, rights violations that constitute human trafficking. What we hear less about is the larger number of victims of crimes committed while they live and work in Europe. And what kinds of crimes are these? Now, these are the kinds of crimes that we're all unfortunately very familiar with: harassment, theft, assault, sexual violence, but also crimes that tend to be commonly committed against people in situations of vulnerability, such as, for example, labor exploitation. And so let's then speak for a moment about the number of people we're talking about. So how many people are currently present with irregular status in the EU? Well, we don't actually know with precision. There's no system in place at the EU level for gathering systematic and reliable data on this. But Eurostat estimates, based on extrapolations from other data that it collects, that approximately 2.2 million people were irregularly present in the EU in 2015, and that number dropped by more than half in 2016. Now, the most systematic study, or attempt to study, the number of people irregularly present in Europe occurred almost 10 years ago as part of a study called Clandestino. And at that time, in the EU 27, it was estimated that between about 2 and 4 million people were irregularly present in the EU. Again, these figures are hard to really pin down. And we know that whether a person is the number of people irregularly present in a particular country is a function of the number of people entering irregularly, which is affected by a number of factors, but it's very much also a function of the prevailing laws that grant residency and the way in which existing immigration laws are enforced. And that is something that shifts and changes over time. Now, how many people are regularly present in Ireland? The Migrants' Rights Centre Ireland has estimated that the number is somewhere between 20 and 26,000 people. So I wanted to turn now to take a closer look at the provisions within the directive itself that are particularly notable and important to underscore when we're thinking about the rights of undocumented victims of crime, the rights of victims of crime who may have precarious or irregular status. So I turn again to our starting point, which is Article 1. And I think it's really important to underscore that Article 1 really establishes a principle of non-discrimination that informs our interpretation of all of the text and the spirit of the Victims Directive. Article 1 makes it clear that all the rights of the directive apply without discrimination to all victims of crime, irrespective of their status. So more concretely, what does this mean? This means that those barriers that we spoke about a few moments ago, the Victims Directive requires member states to remove them, to remove barriers to services, protection, and justice that are linked to a person's irregular status. What this means is it requires a reversal of the usual calculus of putting so that the victim's needs and rights would be put ahead of immigration enforcement priorities. So when we turn to some specific provisions, additional specific provisions of the directive, so these are just a highlight of a few that I thought would be of particular interest and relevance. The first of the list is the right to be treated respectfully, which appears in a number of places within the directive. All victims of crime are entitled to be treated with respect, sensitivity, and dignity by the authorities. And I think a related requirement is that officials who come into contact with victims of crime, including police officers, court staff, lawyers, and so on, are expected to receive training in order to be able to deal with victims in an appropriate and sensitive manner. And what this implies then is that these individuals who come into contact with victims should be aware of the particular forms of vulnerability that are created by a person's irregular status. And they should be in a position to respond with respect and sensitivity and understanding about that person's situation and the kind of vulnerabilities they face. There is the right to be informed. Victims of crime have the right to be informed of their rights and of their case in a way they understand, and to make complaints in a language they understand or else with assistance. Now, this is relevant in a number of ways. Most practically, we might imagine, in ensuring in that it requires that steps be made to ensure that a person whose first language is not the native or national language of a given country, that be accommodated as much as possible, that interpretation be made available, that translation be made available. Now, the third one that I've listed here is the right to a decision not to prosecute. Under the Victims Directive, victims have the right to review a decision not to prosecute their case, to ensure that it respects established rules and procedures and that a correct decision was made. Now, this is important because in our experience, and in the experience of PICUM's members, one of the challenges faced is not only the chilling effect that is created by the real risk that approaching the authorities could lead to detention and deportation, but it's also the reality that in the situations where people do come forward to make complaints, it is unfortunately often the case that their cases are not prosecuted. A disproportionate number of cases, one might say, that are filed by people with irregular status are not vigorously investigated and prosecuted by the authorities. And what the directive ensures is that there is accountability for this, that victims have the right to understand why that isn't happening. Additionally, there is the right to participate in criminal proceedings. This is defined under the provisions of national law, but where victims do have a role in criminal proceedings under national law, they should be able to have the possibility to participate irrespective of their resident status. I think it's fair that by implication, their involvement in the criminal proceedings should not expose them then to immigration enforcement actions. Significantly, the Victims Directive grants a right to services and support. The victims have the right to be informed of what services are available to them. They have the right to access free and confidential services. And the right to services is not conditioned on any requirement to have formally reported the crime. And this is significant, again, because of the reality that very often people are reluctant. People who may very well have regular status have reasons, they may have reasons to be reluctant to come forward to the authorities. This, under the Victims Directive, should not be an impediment to their ability to access services. Now, the next one is a related one. It relates to the right to protection. Victims under the Victims Directive are entitled to individual needs assessments, and they're entitled to specific protection measures for the most vulnerable. They have the right to protection from secondary and repeat victimization, such as interim injunctions and restraining orders. And so I think this is also important, that irrespective of status, all victims have the right to have their individual protection needs assessed and determined and carried out. Now, I wanted to underscore that the Victims Directive gives specific attention to victims of gender-based violence. It recognizes gender-based violence as a form of discrimination, and it also recognizes that victims of gender-based violence often face or require special supports and services and protection, and are at a greater risk of intimidation and retaliation. It also underscores the particular needs of child victims. And under the Victims Directive, there is a specific requirement that where the victim is a child, that the child's best interest shall be a primary consideration. And of course, this is relevant in understanding the approach that is mandated under the Victims Directive when children are undocumented as well. Significantly, under Recital 14, it is clear that the directive should be understood to be consistent, to be implemented in a way that is consistent with the UN Convention on the Rights of the Child. Article 26 has to do with cooperation. and collaboration. And I think it's important to underscore here that there is a strong prevention element as well embedded within the Victims Directive. Under Article 26, member states shall take appropriate action aimed at raising awareness of the rights set out in this directive, reducing the risk of victimization, and minimizing the negative impact of crime and the risks of secondary and repeat victimization. And further, it states that this is particularly the case for groups at risk, such as children and victims of gender-based violence and violence in close relationships. So in considering these particular groups of victims, so child victims and survivors of gender-based violence, I wanted to underscore the relevance of a number of international treaties that can give us some guidance in how we understand and interpret the relevant provisions. The first is the Council of Europe Istanbul Convention, and the second is the UN Convention on the Elimination of All Forms of Discrimination Against Women, and the last is the UN Convention on Child Rights. And so the Istanbul Convention, as many of you may already be well aware, is the Convention on Preventing and Combating Violence Against Women and Domestic Violence. It entered into force just a few years ago in August 2014. Like the Victims Directive, the Istanbul Convention has a broad scope in terms of to whom it is applicable. Under Article 4, it is clearly established that everyone has the right to live a life free from violence. Article 4 also obliges parties to the Convention to implement the Convention without discrimination on any ground, including migration or refugee status. And so again, explicitly on the face of this treaty, member states or state parties are clearly pointed to the fact that non-discrimination in its applicability includes non-discrimination with respect to people on their territory who are not citizens, who may not even be permanent residents, who may not have any proper status at all. Of course, this is consistent with the universal nature of human rights treaties and human rights more generally. As of February of last year, 2017, 27 states were parties to the convention, 18 EU member states among them. And significantly, last June, the EU signed the convention. I think it's important at this stage to note that when we're speaking of the ways in which resident status can make a person vulnerable to particular forms of abuse and exploitation, this is not only the absence of resident status, but as is also recognized under the Istanbul Convention, Article 59, this is also the case. There is also vulnerability within the fact of a person having a dependent resident status. So a person's right to reside being tied to a particular individual, typically a spouse or an employer. And so when the perpetrator of abuse or exploitation or other crime is the person on whom a person's resident status depends, this creates also a situation of vulnerability that exposes a person to many of the concerns that we discussed at the earlier part of this presentation. That is because the risk of reporting, the risk of a breakdown in that relationship can lead to a person finding themselves in a situation of irregularity and precarity. So we need to bear that in mind as we're thinking about the ways in which resident status can affect a person's susceptibility to violence and to victimization more generally. And also, therefore, the ways in which the Istanbul Convention, the ways in which the Victim Directive requires states to take steps to mitigate this, and indeed to prevent this. We turn now to CEDAW. Now, CEDAW has been ratified by every EU member state. And CEDAW, of course, is fundamentally concerned with discrimination and violence against women. The CEDAW committee is the UN committee that is tasked with supervising the implementation of the treaty and also with interpreting the treaty. And in its general comment number 33, the committee has stated that conduct that leads women to systematically underreport due to fear that they will be humiliated, stigmatized, arrested, and deported is a form of discrimination. It has been framed as a form of discrimination. And so those obstacles, those systemic structural obstacles that lead to systematic underreporting, those are issues, those are problems with which the CEDAW Convention is concerned and its rights. Under general comment number 35, the committee specifically urges states parties, in order to be consistent with the duties that are laid out for them within the convention, that they would repeal all legal provisions that discriminate against women, including laws that prevent or deter women from reporting gender-based violence, such as restrictive immigration laws. Finally, I wanted to turn to the UN Convention on the Rights of the Child. Again, every EU member state has ratified this convention. And in November of 2017, the Committee on the Rights of the Child, together with the Committee on the Rights of Migrant Workers, issued a joint general comment, specifically addressing migrant children and their rights. And so if you'll bear with me, I'm going to read some of what the committees have said in their general comment as far as interpreting the rights of migrant children under international human rights law and implications for states. Undocumented migrant children and parents dependent on residence or work permits, who can easily be made undocumented by their sponsor or employer, face risks of being reported to the immigration authorities by public service providers and other officials or by private individuals. This limits their enjoyment of rights, including protection and access to justice, and makes them more vulnerable to violence and to labor and other types of exploitation and abuse. And finally, children and parents must, to be consistent with international human rights obligations of states, must be able to safely report to police and other authorities as victims or witnesses without any risk of immigration enforcement as a result. And so that brings me to the end of my presentation. I think it's useful to finish with the perspective that we have from international human rights law, which is very much binding and applicable for all the member states concerned, including Ireland, and I think is relevant in helping us to understand the rights that are at play, in understanding even what we've discussed previously in terms of the Victims Directive, the kinds of vulnerabilities that are confronting or that people with insecure resident status face, and our understanding then of concretely what states' obligations are to them, including under the Victims Directive and in its implementation. And so, again, I think the appropriate starting point is Article 1, in understanding that all the provisions of the Victims Directive and the rights therein are to be applied in a non-discriminatory manner. And so the first step in ensuring this is really ensuring that there is an understanding about the forms of entrenched discrimination that exist that impede people's access to services, justice, and protection. And when we can understand that embedded and structural reality, then we are in a position to understand the steps that must be taken to correct it, and then the specific obligations on member states to take those steps proactively. I have listed just a few resources here And I will provide others to the training organizers that can be made available to you. Thank you very much for your time.